Okay, so about 5, 6 months ago, there was a trial that got pretty big. It was this dude, Gerhardt Konig, in Hawaii, and he was on trial for attempting to kill his wife, Ariel Konig. They were on a hike, and he tried to push her off a cliff. He hit her with a rock, all allegedly, all supposedly. So Chelsea and I were very into this trial. So Chelsea, you're going to want to watch this video because we're about to get back into it. So if you guys weren't caught up on that trial, basically this guy, let's see, he was accused of trying to murder his wife on a cliffside hike, and they convicted him on attempted manslaughter, okay? So attempted manslaughter there in Hawaii it's up to 20 years in prison, and he was set to be sentenced on the 13th of August, which is 2 days from now. So here comes the sentencing, right? As I've been following the case, where's the sentencing? Where's the sentencing? There is no sentence. They're delaying the sentencing. So his lawyer is trying to get that trial thrown out and trying to get a new trial going. And so they're delaying the sentencing on the 13th, and they're going to have a hearing for this motion right here for a new trial, okay? And his lawyer caught a lot of flack during the trial because this guy is accused of attempted murder, so everybody thought he was the bad guy. But I thought his lawyer did a good job fighting for his client. I thought he did a real good job. So I'm going to go over this entire motion if you guys haven't seen it. And we're going to go over this, the motion his lawyer filed. This is Gerhardt Konig's lawyer filed to get a whole new trial going based on some of the things that the jurors said after the fact, right? So this is very interesting, what happened. This is all after the trial, right? So here we go. Motion for a new trial. Okay. Defendant Gerhardt Konig, through his counsel Alapa and Otaki, respectfully moves this honorable court for an order granting him a new trial. The federal and state constitutions ensure both a fair trial and a verdict that comports with due process, right? Double jeopardy 10, due process 5. To facilitate these protections, the Hawaii revised statutes permit a court in any criminal case to grant a new trial for any legal cause and to set aside a jury verdict when it appears to be so manifestly against the weight of the evidence as to indicate a misunderstanding of the charge of the court on the part of the jury. So this is setting up, he's basically saying that the jury misunderstood the judge's instructions, right? And so the verdict that they pushed down should not be, on the books, so to speak. Revised statutes, the rules of penal procedure further grant this court the ability to grant a new trial to the defendant if required in the interest of justice. Hawaii rules of penal procedure. So here the court should exercise discretion, order a new trial based on legal cause and to facilitate justice, as jury irregularities call into serious question the integrity of this verdict. So he's saying this verdict should be thrown out because of some of the things that the jury said after the fact. Which we'll get into here in a second. So this is going to be very interesting. So this guy, if you guys watch this whole trial, this guy said he was innocent, right? The whole thing became basically because there was video of her coming down the mountain. She was all bloodied up, right? But he said it was self-defense, that she attacked him. And so there was basically she did get damaged. There was some damage that occurred that he did to her up on that mountain. And at the end of the day, it was all up in the air. The jury did come down with an attempted manslaughter verdict, okay? So this motion is brought pursuant HRPP 33, Hawaii State Constitution. It's also based on the court record, state provided discovery in this matter, as well as accompanying memorandum in support, declarations, any accompanying exhibits, okay? So Thomas Otaki, this is attorneys for the defendant. So this is attorneys for Gerhardt Konig, okay? So this is the table of contents here. So this is to keep in mind, on the 13th, 2 days from now, this dude was going to get sentenced for attempted murder. That's up to 20 years. And his position is that it was self-defense, right? And that the wife, during this trial, the wife, he didn't accuse her of cheating, but it was like she was having some conversations there with a coworker and all this kind of stuff, right? So it was a volatile relationship. It was a relationship that was, but it's hard because it's up and down. All relationships are up and down, right? But you can't just beat your wife's head in with a rock, basically, right? Introduction. Dr. Gerhardt Konig was tried on a charge of attempted murder in the second degree arising from the alleged attempted killing of his wife. Okay, so tuck in. This is 23 pages. A lot of this is just exhibits, but I'm going to try to go over this. There's a lot of like paragraph writings. So, get yourself your little wine or whatever it is you need, and let's get into this. His wife, Gerhardt Konig, on April 8, 2026, after a multi-week jury trial, the jury returned a verdict finding Dr. Konig guilty of attempted manslaughter based on the extreme mental or emotional disturbance, EMED. This motion arises from significant concerns about the validity and integrity of that verdict. So this entire motion, he wants a new trial. He's saying that the verdict that the jury returned, it should be thrown out. Following the verdict, 2 jurors voluntarily gave public interviews to media outlets. In those interviews, the jurors repeatedly indicated that they did not believe Dr. Konig intended to kill his wife, while describing findings more consistent with reckless conduct than specific intent to kill. So this was one of the whole things, during this trial. Was it just a heated argument that blew up, right? Which either side caused, right? Was it just a situation? Or did he take her hiking up there and attempt to murder her and try to kill her and plan this in advance and took her up to that mountain to bash her head in with a rock and kill her, right? Who done it? Jury repeatedly indicated they did not believe Dr. Konig intended to kill his wife, while describing findings more consistent with reckless conduct than specific intent to kill. The state also disclosed information suggesting a juror may have communicated during deliberations with an individual watching a live stream of the trial proceedings. So unless we read these motions, it's really easy to be like, oh, F this guy, and this guy's a murderer, and he should be sitting in jail, and now there's something fishy going on, and now they're trying to do a retrial, and the system's corrupt and all this. But as you read this, right, as you read what the jury said after the fact in these interviews and whatnot, which we'll get into, it's kind of interesting. So this motion raises 3 distinct claims in support of conducting a new trial. First, the jurors' post-verdict statements, including the attached declaration of jury foreperson, strongly suggest that the jury misunderstood the court's instructions by returning a guilty verdict despite expressed doubt regarding the required intent for that offense. So they're saying the jury misunderstood the judge's instructions because the jury's saying they expressed doubt that he intentionally tried to kill her, but they still returned the verdict. So that indicates to this lawyer that the jury misunderstood the instructions. This concern falls comfortably within Hawaii revised statutes, which authorizes a new trial for legal cause or where the verdict reflects a misunderstanding of the court's instructions. Likewise implicates fundamental due process concerns, Hawaii Rules of Penal Procedure, a new trial in the interest of justice. No person should face 20 years of imprisonment because the jury misunderstood the law. Right there, that sentence is very important. No person should face 20 years of imprisonment because a jury misunderstood the law. I also need to say that I am not a lawyer. This is just very interesting to me. This one in particular is very interesting to Chelsea too, but these videos are getting posted because I have no one to talk to about this and I am just invested in it. Second, the jurors' public remarks raise a serious concern that the verdict may rest upon findings inconsistent with the convicted offense. Although attempted EMED, emotional distraught or whatever, manslaughter still requires proof of an intent to kill, the jurors publicly described conclusions framed in terms of conduct that could result in death or had the capacity to kill, while simultaneously stating that they did not believe Dr. Konig intended to kill his wife. So they're saying there was actions that could potentially lead to her death, at the same time saying they didn't believe that he had intent to kill his wife. He didn't go up there planning to kill her, which is honestly what I thought at the time. I thought it was a messed up situation. I thought they got in a fight up there. I thought it turned, ugly up there, but I didn't think he planned and coordinated this attack to kill her up there on top of that mountain. Hawaii law, however, does not recognize attempted reckless manslaughter because attempted liability requires specific intent. The jurors' statements, therefore, raise a serious question as to whether the verdict rests upon a legally impermissible theory of guilt. Okay? Post-verdict disclosures produced by the state raise concerns about possible outside influence during jury deliberations. This is interesting. Specifically, the disclosure suggests that a juror may have communicated via cellular device with an individual publicly commenting on a live stream of the trial while deliberations were ongoing. That's a big no-no, right? So they're saying someone in the jury, because if you listen to these jury instructions, they specifically are asked not to contact anybody, not to communicate with anyone outside of the court, which I always find very interesting, because it's what? Like, it's essentially the honor system. If I'm on the jury and I go home, I've got my phone, they basically asked me to not look up any of the trial so that I have an impartial, understanding. But it's like, man, how you gonna police that, But this they did police. The commenter accurately predicted the jury's ultimate verdict before it was publicly announced and used specific terms that later matched jurors' post-verdict statements. Although the full scope of any such communication remains unknown, these circumstances raise substantial concerns regarding the jury's exposure to outside influence or extraneous information during deliberations. Look, the bottom line is, if the jury did something they weren't supposed to do, if the jury was contacting someone they weren't supposed to contact, right? If they weren't following the procedures, then yeah, this dude deserves a new trial, right? Independently and collectively, these circumstances raise objective issues regarding the reliability and integrity of the verdict and whether the deliberative process protected Dr. Konig's constitutional rights to due process and a fair trial, his statutory rights under HRS, and the interests of justice protections embodied in HRPP 33. Under these circumstances, the court should grant a new trial and ensure that any retrial comports with double jeopardy limitations discussed below. So this is super interesting, because this isn't like, oh, we found new evidence that he didn't hit her, he didn't attack her, this, that, and the other. This is like a side thing that may be beneficial to him. He still is in the same position as far as like what he did and what happened. All of that information is still the same. It's not like, oh, we've got a brand new video that wasn't available before that showed that she jumped on him and attacked him. All of that is still the same. This is something totally on the side that a juror did after the fact that's now impeding, procedures. Now, this is HRE 606. Basically, this describes describes how they're basing this decision, right? So because this motion arises from post-verdict juror statements and evidence suggesting outside influence during deliberations, the court must first consider HRE 606. HRE 606 distinguishes between impermissible inquiry into jurors' subjective mental processes on the one hand, and permissible consideration of objective misconduct. So HRE 606, they're not allowed to question the jury's mental process during deliberations. But if there's objective misconduct, so like what they're saying, this juror is on camera giving interviews. This isn't about the juror's mental process. They're straight up giving interviews and talking to cameras and news outlets. Influence bearing upon the integrity of the verdict, on the other hand. Generally, HRE 606 prohibits juror testimony concerning the effect of anything upon a juror's mind, emotions, or mental processes during deliberations. But the rule does not impose a blanket prohibition against judicial inquiry into alleged misconduct. So they're saying that this HRE 606 doesn't allow the lawyer to come back and start questioning what the juror was thinking during deliberations. However, it doesn't. Well, we got like a tornado going on outside. Instant tornado, not even a thunderstorm. However, it doesn't prohibit all inquiry. So if there's potential misconduct, you can go ahead and ask about it, especially if it's objective, especially like they're saying that this person was on camera and all that. If there's a tornado, if my house gets taken away, this video is going to cut off. If there's, objective information like this jurors giving interviews, they can definitely question that. They just can't come back and question what was going on in the juror's mind as they were deliberating, right? They can't, start saying that's incorrect. What you were thinking and how you were processing is incorrect. That they're saying, no, what you're doing. This is what contains to what you were doing after the fact. Rather, the HRE 606 commentary explains that the dividing line is between testimony concerning jurors' subjective mental processes, which remain prohibited, and testimony concerning conditions or occurrence of events calculated improperly to influence the verdict, which may properly be considered regardless of whether such events occurred inside or outside the jury room, right? HRE 606 commentary. Commentary further explains the rule seeks to strike a proper balance by excluding testimony relating to the internal deliberative process and allowing testimony about objective misconduct and irregularities. So same thing, basically here, what they're saying is you can't question a juror's thinking during deliberations, but you can question objective misconduct, which is what they're saying this is, okay? These principles are especially important here because this motion implicates Dr. Konig's constitutional rights to due process and a fair trial by an impartial jury. So if the jury's going out here going, we thought he didn't intend to kill her, but we returned a verdict of manslaughter because we were confused, yeah, that's not impartial, right? As well as statutory, and that's not a fair trial, is it? Verdict affected by legal error or misunderstanding of the court's instructions. Hawaii courts have repeatedly recognized that evidentiary rules may not be applied mechanistically, where doing so would undermine fundamental fairness or the integrity of adjudicative process, right? Accordingly, the court may properly consider the juror's voluntary public statements and the evidence concerning possible outside influence for the limited purpose of determining whether there exists a reasonable possibility that the deliberative process or resulting verdict was tainted by legal error. So they're trying to see if there's a possibility that the verdict was tainted by a legal error, objective irregularity, or improper external influence, right? So they're trying to find out what happened. Is this were they texting outside of this with someone they weren't supposed to? Did they misunderstand the jury instructions? What happened, right? Factual background, this is going to get a little bit interesting here. This is where they're going to start doing quotes and all that stuff. Following the verdict, a jury foreperson voluntarily gave interviews to True Crime AZ and East Idaho News. Exhibit A is the jury foreperson statement of True Crime AZ, and Exhibit B is the foreperson's longer interview with East Idaho News. Okay, so I'll be bouncing back and forth and trying to find the exhibits so we have a real good view here. 1. Statements concerning intent to kill. In her public statements, the foreperson repeatedly stated that the jury did not believe that Dr. Konig intended to kill Ariel Konig. Keep in mind, they returned a verdict of attempted manslaughter where they said he intended and attempted to kill her, right? So this is all right. Speaking with True Crime AZ, the foreperson stated, the intent to kill is improbable to us based on the evidence presented. Exhibit A at 0000 through 0009. So Exhibit A here. Let's listen.
The intent to kill is improbable to us based on the evidence presented.
Okay. The intent to kill is improbable to us based on the evidence presented. So why'd the verdict get returned that he had intent to kill? The foreperson made similar statements during her interview with East Idaho News. When asked why the jury chose attempted manslaughter and not attempted murder, the foreperson replied that the jury concluded there was definitely a scuffle that resulted in injury to the head that could be bodily injury and serious. Exhibit B at 316 to 355. Let's listen to some of it.
The reason for attempted manslaughter, I think, came down to the reality of that of what the testimony said. So there was definitely a scuffle.
So there was definitely a scuffle, right? That resulted in injury to the head that could be bodily injury and serious. But where is the attempted murder, right? There's definitely a scuffle.
That was that had happened at that location on the Palipuka that resulted in somebody having bodily image. I'm so sorry.
That's
Can I
okay.
start over?
Yes,
okay.
of course.
Okay, yeah. So we did.
Yeah. So this juror's catching some heat right now for the for what she went and said. When further asked about the jury's belief, so 316 and 355, let's see.
Determined that there was definitely a scuffle on top of the Palipuka Trail that resulted in an injury to the head that could be bodily injury and serious.
Right. So there was a scuffle. There was a scuffle that was at the top of the hill, right? That resulted in bodily injury that could have been serious. So scuffle, that's mutual or not. That's a fight, right? When further asked about the jury's belief that Dr. Konig wasn't trying to kill her, the foreperson replied, ultimately, we just agreed that Ariel Konig was definitely hurt with a bodily injury to the head that could result in serious bodily injury. Exhibit B at 510 to 528, right? So...
ultimately, we just agreed that per the instructions that we were given and the definitions that we were set to look at and focus on, that somebody was definitely hurt with a bodily injury to a head. That
Okay. With the court's permission, defense counsel later contacted the foreperson to ensure her statements were not being misunderstood. In the attached declaration, they're attaching a declaration from this juror here in this motion. The foreperson confirms that she voluntarily made the statements attributed to her in media interviews and reaffirms that the jury did not believe Dr. Konig intended to kill Ariel Konig. Declaration of Makalapua Atkins, sorry for the pronunciation. The foreperson also attests she believed Dr. Konig was not guilty of attempted murder. Right there. So this is a juror after the fact saying this guy was not guilty of attempted murder. 2. Statements concerning recklessness and emotional disturbance. In describing the conduct underlying the verdict, the foreperson repeatedly referred to actions that could result in serious bodily injury rather than conduct undertaken with an intent to kill. The foreperson, we're talking about up to 20 years in jail for attempted murder. Are we saying this is a good guy? No. But are we saying this is one side? Right? So look at relationships and how complex they are. Almost anything could happen, right? And so there's a fine line between a fight and where he hits her with a rock, which makes him a piece of shit. Yeah, sure, it makes him a piece of shit. Don't hit a woman, all of this. And him planning for months to take her on a hike where he pushes her off a cliff and tries to kill her. Big difference, right? Maybe you guys think there's a big difference, or just throw away the key either way. In describing conduct underlying the verdict, foreperson repeatedly referred the action could result in bodily injury rather than conduct undertaken with an intent to kill. The foreperson also stated that the jury believed Dr. Konig struck Ariel Konig twice with a rock during the incident. Okay, Exhibit B at 357 to 422.
He struck her with the rock. How many times do you think that happened?
in his testimony, he did state that he hit her with the rock 2 times.
And did you believe that, or do you think it was more?
I think the valid evidence of that we were presented could stipulate that that she was definitely hit twice.
Yeah. So Ariel struck twice with a rock, right? The foreperson additionally discussed the jury's finding concerning emotional disturbance. She stated that the jury believed that someone that's been married to someone for 8 years, in a relationship for that long, and having some kind of affair happen after having 2 young kids under the age of 2 might have some kind of emotional disturbance. She emphasized on both sides, right? Exhibit B, 604 to 632. Right?
That inflamed the situation? Do you think that was the root of his emotional distress?
I'm not necessarily sure if that was the root, but I do commonly believe that somebody that's been married to someone for 8 years, in a relationship for that long, and having some kind of affair happen after having 2 young kids under the age of 2 might have some kind of emotional disturbance on both sides.
Yeah, so the some kind of affair happen is questionable, because Chelsea and I were talking about this during the trial. They released the texts between Ariel Konig and this coworker, or they didn't release the text. They released some of the texts and they redacted a lot of them. And this, I don't know if I would call this an affair. They were definitely flirty, but I don't know if I would call it a full-on affair, right? So look, something like this, right? So here she is. I guess we will watch some football here too. Gee, that's Gerhardt is on call. I'm planning to decorate the tree with the kids. Coworker says, gotcha. Right? So it's stuff like this. It's this friendly texting. How's your day? They're talking about music. They're talking about, do you like this artist? Do you like this artist? It's definitely friendly. And just from, put it this way, from being in a similar situation, I was the guy texting, let's say, when I was single. Let's not get too far into it. They're friendly texts, they're flirty texts, but I don't know if I'd go so far to call it a full-on affair, So the foreperson additionally discussed the jury's finding concerning emotional disturbance. Yeah, someone's been married to someone on both sides. The foreperson further explained that the jury selected the emotional distress option on the verdict form because the jury hoped that any type of help for both sides, emotional-wise, can be had, right? During her East Idaho News interview, the foreperson twice referred to the verdict form option as separate counts. She stated that the jury focused on what each count was. Exhibit B, 130 to 135. So here's Exhibit B.
Focus on what the instructions were and what each count was. And so because of that, we were needing an extra.
Okay, so what each count was. She later explained that the jury's conclusions were based on the definition of the counts. Okay? Juror number 3's public statements. Juror number 3 also voluntarily spoke with KHON2 News following the verdict. Relevant excerpts are attached as Exhibit C. Juror number 3 confirmed that the jury rejected the attempted murder charge. Exhibit C at 1 minute through 1 minute 9. Okay?
Rejecting the attempted murder charge and ultimately based their verdict of attempted manslaughter on the legal definition, including emotional distress.
I think he was...
Okay. For attempted murder charge C, he further stated, I don't know if he was trying to kill his wife, but added that Dr. Konig's conduct had the capacity to kill his wife. So if my conduct has the capacity to kill my wife, right? But that doesn't mean that I was intentionally going to try to kill my wife, right? That's different things. Exhibit C at 0110 through 125.
Is emotionally unstable. I don't know if he was trying to kill his wife personally. I do know that it was the capacity to kill his wife.
Okay. So it was the capacity to kill his wife, right? Juror number 3 also stated that he believed Dr. Konig was emotionally unstable. Information disclosed by the state concerning outside influence. Following the verdict, the state disclosed information indicating that a deliberating juror may have communicated during deliberations with an individual publicly commenting on a live stream of the trial proceedings. Specifically, during the deliberations, a viewer posted the following public comment on Law and Crime's YouTube live stream. I've been texting with one of the jurors and they're going for count 3, attempted manslaughter. Exhibit D at 2. Okay? So look. Here's 1, 2. I've been texting with one of the jurors and they're going for count 3, attempted manslaughter. Can't do that. You can't text with one of the jurors. You can't be doing that because you're going to get your shit thrown out on a technicality. The commenter accurately predicted the jury's ultimate verdict before it was publicly announced. The commenter also referred to count 3 attempted manslaughter terminology similar to the foreperson's later public references to the verdict form options as separate counts. Argument. To convict Dr. Konig of attempted murder in the second degree, the jury was required to find beyond a reasonable doubt that he intentionally engaged in conduct constituting a substantial step towards causing Ariel's Konig death, and he acted within the intent to kill or knowledge that death was practically certain to result. So he's saying, this lawyer is saying, this is Gerhardt Konig's lawyer, is saying, to convict him of murder, attempted murder in the second degree, they had to find beyond a reasonable doubt that he planned this, intentionally engaged. It can't be an argument that caused a fight that he then attacked or she attacked him and he's defending, she's defending. He had to have known, taken steps, and knew this was going to happen, which is what they were the prosecution was trying to prove this in court, that he was searching up hikes, dangerous hikes, yada, 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 that he was planning all this, right? But when the juror's out there after the fact going, he didn't intend to kill her, I mean, that kind of brings question to the whole thing. Not saying that the jury's a bad jury or that the juror's a bad person, but there may have been a misunderstanding or a different kind of thing. But now that they're coming out and saying it, now that this juror's doing interviews, now this defense lawyer is grabbing hold of it, seeing this as a chance for a new trial. So this is a good lawyer, in my opinion, right? Because he could just, we had the verdict, it's attempted manslaughter, it's done, let's do it, right? And now that it's all over, the juror's giving interviews, it's all done. But no, this lawyer's saying, wait a minute. Let's try this. I think I have something here. Let's try this, right? Attempt liability requires specific intent to commit the underlying offense. Accordingly, attempted murder requires proof that the accused specifically intended to kill. The EMED manslaughter defense does not eliminate the intent to kill element. Rather, it mitigates what would otherwise constitute murder to manslaughter, where the defendant acted under the influence of extreme mental or emotional disturbance for which there's a reasonable explanation, right? Thus, attempted EMED manslaughter still requires, even if it's emotional, still requires proof that the defendant intended to kill. So they can't be out here saying he didn't have an intent to kill. Consistent with these principles, the court instructed the jury that if it did not unanimously find beyond a reasonable doubt that Dr. Konig acted with the required intent for attempted murder, it was to proceed to the lesser assault offenses rather than return a verdict of attempted EMED manslaughter. Hawaii law does not recognize the offense of attempted reckless manslaughter because attempted liability requires specific intent. Look, I don't think it's okay to hit a woman. I don't think it's okay to attack your wife. I don't think it's okay to hit your wife with a rock. If you think your wife is having an affair, if you think your wife is cheating on you, leave. I know it's hard. I know it's difficult. This is some of the conversation that Chelsea and I have in our house. It's a difficult decision. Leave. But when you take a situation to the point where there's a physical altercation, you're opening yourself up to these exact kinds of problems, right? That being said, if he didn't plan to kill her, he should not get 20 years or up to 20 years for planning to kill her. He shouldn't. If it was a fight, if he beat her up, if there was an assault, if there was injury, try it on that. So if this juror is coming out after the fact saying, we thought there was no intent to kill, then yeah, man, I believe the guy should get a new trial. Does it make him less of a piece of shit? I don't know. I don't think so. Did he still hit his wife with a rock? There was video of her coming down the mountainside bloody. But there's a difference between piece of shit and piece of shit who intended to kill his wife, who deserves 20 years in prison, right? There's a difference. The jurors' public statements raised substantial concerns of irregularities in the jury's application of the court's instructions, specifically concerning the intent required for attempted murder, attempted EMED manslaughter. And then this is definitions right down here. As discussed above, attempted EMED manslaughter still required the jury to find beyond a reasonable doubt. And if the jury's coming out and saying that he didn't have intent to kill, but they're returning an intent to kill verdict, that's not reasonable doubt. That's not beyond a reasonable doubt. They're literally doubting it. Yet the foreperson publicly stated that the intent to kill is improbable to us based on the evidence presented. Exhibit A at 0 through 09. Emphasis added. The foreperson later reiterated that the jury believed Gerhardt Konig suffered injuries that could result in serious bodily injury. But if she suffered injuries that could result in serious bodily injury, that's not death. While expressly agreeing that Dr. Konig wasn't trying to kill her. Guys, when you're relying on the jury, you can't have this. Exhibit B, 510 to 528, juror number 3, I don't know if he was trying to kill his wife. That is not beyond a reasonable doubt. That is literally reasonable doubt while describing conduct with the capacity to kill. These statements are fundamentally inconsistent with the verdict the jury returned and reflects irregularities between the jury's publicly stated findings and the legal elements required for the verdict. Under the court's instructions, if the jury did not unanimously find beyond a reasonable doubt that Dr. Konig specifically intended to kill, the jury must proceed to the assault instructions. I believe if this is all legit and we looked at the exhibits where this person was saying it as cited, yeah, they should have moved to the assault instructions. The juror's public statements therefore confirm that the jury misunderstood or misapplied the court's instructional framework in reaching its EMED manslaughter verdict. That concern directly implicates HRS 635, authorizes a new trial where the verdict reflects a misunderstanding of the charge of the court or part of the jury. Likewise implicates obligation to ensure that conviction rests upon findings consistent with the elements required by law, right? Conviction carrying a potential 20-year sentence cannot reliably stand where jurors publicly state that they did not believe the defendant intended to kill, yet nevertheless returned a verdict requiring intent to kill. That's not 20 years. You can't put a guy away for 20 years for this. The verdict raises reasonable possibility the jury convicted on a legally impermissible theory, okay? The jurors' public statements also raise substantial concerns regarding irregularities in the legal theory supporting the verdict. As discussed above, Hawaii law does not recognize the offense of attempted reckless manslaughter because attempt liability requires specific intent. Attempted EMED manslaughter still requires proof beyond a reasonable doubt. Here, however, the jurors publicly described their conclusion that Dr. Konig's conduct could result in death or had the capacity to kill his wife, while simultaneously stating they did not believe Dr. Konig intended to kill his wife. Right? Those statements do not reconcile with the specific intent finding required for attempted EMED manslaughter. Instead, it resemble recklessness-based reasoning inconsistent with the Hawaii's attempt statute. Stanley is particularly instructive, tracing the history of non-existent offense of attempted reckless manslaughter. There, the Hawaii Supreme Court held that a conviction could not stand where the record demonstrated a reasonable possibility that the jury convicted on a legally non-existent offense of attempted reckless manslaughter. So they can't convict them on something that doesn't exist. It's non-existent offense. The court emphasized that where the record reflects jury confusion concerning the distinction between attempted EMED manslaughter, attempted reckless manslaughter, the resulting conviction cannot reliably stand. So if the jury's confused between attempted reckless manslaughter, if it's reckless, or if it's motivated by emotional, it can't reliably stand. Error right there. Same concern is present here. The jurors' public statements repeatedly disavowed any finding that Dr. Konig intended to kill his wife while simultaneously describing conduct they believed merely carried the capacity to kill or could result in death or serious bodily injury. Okay? Those objective irregularities raise at least a reasonable possibility that the verdict rested upon an impermissible theory in direct conflict with the intent element required by Hawaii law. Okay? So here we go. To be clear, Dr. Konig does not ask this court to probe the jurors' subjective mental process or reconstruct the course of deliberation, right? So we're not arguing what their thought process was, nor are we asking them to redo the course of deliberations. The concern instead arises from the objective inconsistency reflected in the jurors' own public descriptions of their findings. When this juror comes out and say, we did not believe he had intent to kill, but they return a verdict that was intending to kill, that's inconsistent, right? The jurors voluntarily spoke with media outlets after the verdict. They were not harassed and based by the defeated party in an effort to undermine the verdict. So Konig didn't go to these jurors afterwards and go, hey, come on, can you go out and do some interviews? These jurors voluntarily did interviews. Under HRE 606, authorities discussed above, the court may properly consider those irregularities to determine whether the verdict possibly rests upon a legally impermissible theory, right? Circumstances cannot support a reliable verdict. The court should therefore order a new trial. And then C is possible outside influence. So this is that live stream post. A criminal defendant is constitutionally entitled to a verdict based solely upon the evidence admitted at trial in the court's instructions. Possible outside influence upon a deliberating jury therefore raises serious concerns regarding the integrity of the verdict and the fairness of the proceedings. If you guys watch any of these court cases, when they do the jury instructions, the judge always tells a jury, do not discuss this case with anyone else. Do not discuss this case with anyone else, right? So when you see this, right, I've been texting with one of the jurors and they're going for count 3 attempted manslaughter. Do not discuss this case with anyone else. I've been texting with one of the jurors, right? The United States Supreme Court has recognized that private communications with jurors during trial concerning matters before the jury are presumptively prejudicial, and the burden rests heavily upon the government to establish harmlessness, right? Here, so they're saying we do believe that it could affect the outcome if a juror communicates with someone outside of the courts or who's in the case. Here, the state disclosed information indicating that during deliberations, at least one juror communicated with an individual publicly commenting on a live stream of trial proceedings. Specifically, while their deliberations were ongoing, a viewer posted the following public comment on Long Crime's YouTube live stream. I've been texting with one of the jurors. They're going for count 3 attempted manslaughter. The commenter accurately predicted the jury's ultimate verdict before it was publicly announced. That's a big problem, right? The commenter also referred to count 3 attempted manslaughter, nearly identical terminology to the foreperson's later public references to the verdict form options as separate counts. The commonality is important because neither the jury instructions nor the verdict form use the term count in this way. So they're saying this is very specific, right? This person was using terminology that the juror was later using, and it's the only way that this person would have known to use this terminology is communicating with the juror outside of when they were supposed to, right? The specific reference to count 3 is also significant, as attempted manslaughter was a third option on the verdict form, but the verdict form had not yet been made public at the time of the commenter's post. Right? Although the present record does not establish the precise scope of substance of communication, the disclosure sufficiently raises significant concerns about the outside influences during deliberations. So they're saying double jeopardy consequences. Under these circumstances, a new trial is warranted. Yeah, if you're not supposed to speak with anyone about the case and you're speaking with someone about the case, that's a no. We're talking about a guy going to jail for 20 years of his life. Potentially 20 years. Although Dr. Konig seeks a new trial, the jury's verdict also carries constitutional implications for any retrial proceedings. The jury did not convict Dr. Konig of attempted murder in the second degree. Instead, it returned a verdict of an attempted EMED manslaughter. The EMED is the emotional. Under settled Hawaii double jeopardy, the verdict operates as an acquittal of the greater attempted murder charge. So under Hawaii law, because they returned a verdict of attempted manslaughter, the lawyer is saying that means they acquitted him of second degree attempted murder, right? Accordingly, if this court grants a new trial, retrial on attempted murder in the second degree will be constitutionally barred. So this lawyer is he's going to work right here. He's going, so the first case, he was on trial for attempted murder, but the jury returned a verdict of attempted manslaughter because of emotional distress or whatever. So because of Hawaii law, because they returned that verdict of attempted manslaughter, that means by Hawaii law, they acquitted him of the second degree attempted murder charge, which would have a higher sentence, higher punishment. So he's saying now if we get a new trial, because the jury acquitted him technically of the higher charge, that higher charge should now not be presented. Now, as I read this and think about it, I'm going, wait a minute. But if you're saying that what the jury said was inconsistent, so we got to basically scrap what the jury said because of their comments after the fact, because of their misconduct after the fact, how can we scrap all that, but then still say they acquitted him on the higher charge? That's a question I have. Again, I'm not a lawyer, so I don't know. But just reading through this, I'm going, if you're saying this jury's unreliable, because he doesn't want him, the new trial, he doesn't want him to be able, because if they go, cool, we'll scrap everything, we're going to give you a brand new trial. Well, if attempted murder is still on the table, they might come back and convict him of the higher charge on this second trial. So this lawyer obviously doesn't want that. So he's saying, nah, we can't do that. But I'm asking, if you're saying the jury's, you got to throw out what the jury said, how can you then come back and then hold the acquittal to be true also? Conclusion. For the foregoing reason of any additional authorities or arguments on the defense submits in support of this motion, Dr. Konig respectfully requests that this honorable court vacate the judgment entered against him and order a new trial. The objective irregularities reflected in the jurors' public statements, together with the concerns regarding possible outside influence during deliberations, raise substantial questions regarding the reliability and integrity of the verdict that cannot be reconciled with due process or the interests of justice embodied in HRPP Rule 33. A conviction carrying potential 20-year sentence should not stand under these circumstances. So they filed this May 15, 2026, right? And then the second part here is the declaration of counsel. So the counsel, Thomas Otaki, declares the following factual assertion. So this is the exhibits are true that they're presenting here. So this is just a declaration that he's saying this is all to be true. And then they have this juror came and did a declaration. I was the foreperson on the jury. I stand by the statements I voluntarily made to the media after the verdict. The jury did not unanimously believe that Dr. Konig had an intent to kill his wife. I did not believe that Dr. Konig had an intent to kill his wife during the incident. And I believe that he was not guilty of attempted murder. I declare under the penalty of law that the foregoing is true and correct to the best of my knowledge and belief. So they brought this juror back to say, I did say all this, and I do not believe that this guy is guilty of attempted murder. So this can be, in my opinion, this can be pretty big. So here's a potential juror misconduct. Here's an email received during the Konig trial. I was watching the proceedings live stream when I noticed a comment. There's basically an email about the comment that was posted, claiming to be communication with someone inside the jury room during deliberations. I've attached a screenshot of the comment. So here's the comment, right? Again, and we went through this. So basically, guys, this is very interesting. If the jury did some misconduct after the fact in these interviews and all that, then maybe this guy's going to get a new trial. As it stands right now, the sentencing is delayed. Right? On the 13th, it's delayed. And on the 14th, there's a hearing to see what's going to happen. So I'm going to be following this, but I want to know what you guys think. If you guys are following this as well, I want to know what you guys think of this. This is interesting. If this is in fact the case, this guy's looking at 20 years. And if we're doing everything by the book, this jury can't come out and say, we didn't think he intended to kill his wife, and then return a verdict that says he intended to kill his wife. That's not fair to the guy. You guys think Konig's going to get a new trial or what? All right, we'll be back with more videos, guys. Later.